Morning, everybody, and welcome to the third and last Brodie's Energy Academy session of our autumn series. My name is Iain Rutherford, and I'm an energy disputes lawyer practicing UK-wide and internationally in court proceedings, arbitrations, mediations, and expert determinations. And myself and my team regularly advise on JOA disputes, which is what we are going to be talking about today. Today's presentation will be delivered by Fiona Chute, who's here on screen with me and myself. Fiona is a senior associate in our litigation team, and her practice is primarily in commercial dispute resolution and alternative dispute resolution. She works with me to manage and resolve complex and high-value energy disputes. Okay, I think that's us. I think we've got the numbers that we were looking for. Unless you have any objection, Fiona, I'm planning to get started.
Yep, go ahead.
Good. So I think just the initial summary of the learning objectives that we're looking to cover today. So what we're going to be speaking about, contractual interpretation of joint operating agreements. We'll have a case law update on obligations of good faith in joint operating agreements. And then we'll take that good faith point further by looking at common issues which arise in JOA disputes, reasonable and prudent operator, the exercise of contractual discretion, and fiduciary relationships. And then we'll have a brief summary of kind of key cases at the end. So just moving on to the next slide. I think we say this quite often when we speak about JOA disputes, and I know that many of us in the webinar will have had the same issues that we have. You would expect there to be a lot of judicial authority dealing with JOAs, given how long these agreements have been in use, given that they follow fairly standard forms, and given the significant sums that are often at stake in JOA disputes. But that's not the case. So just moving on to the next slide. There isn't a huge amount of judicial guidance, and that's why I think we all tend to get quite excited when we do have a case or a new case that covers some aspect of it. And we, as I say, we've summarised at the end of this really the kind of key cases that I expect you should really be looking at when you're looking to interpret JOAs or you're dealing with a JOA dispute. Now, why is it that we don't see these disputes coming along all that often? Well, I think it's probably a compliment to many of you on the call. There are often escalated dispute resolution mechanisms, JOAs, which mean that many of them don't get to that stage. But I think it's also, generally speaking in this industry, there's a lot of sophisticated operators, and by that I don't mean capital O operators, who are working together, and generally, given the joint venture nature of these sorts of arrangements, there is a fairly significant incentive to try and resolve these sorts of disputes before they escalate, or certainly before they require to be litigated. So it will only really tend to be where there is just a really fundamental point of contractual interpretation that just is not capable of resolution that you really see these things being litigated. So in a way, the frustration that us lawyers have at the absence of authority is probably a compliment to those of you in the room that actually it's a sophisticated industry, and there is, generally speaking, there is an appreciation about the benefits in avoiding litigation and then trying to achieve kind of sensible, workable solutions rather than having the kind of black and white interpretation which you might end up with in a litigation. The other reason, of course, is that a lot of particularly more kind of international JOAs will have arbitration provisions rather than litigation, meaning that you lose the benefit of precedent emerging from those, because that, by its very nature, is a private process. We've certainly been involved in a number of arbitrations, and obviously you're citing case law, but what you're doing is citing judicial authority to support the points that you're making, but you know that there is an awful lot of this going on behind closed doors in arbitration, and some useful precedents that are just not available by virtue of that process. So that's just, I think that's my thoughts on why we have fewer of these than you might expect. But as I say, frustrating though it is, I don't think that is actually a bad thing, and it probably reflects well on the industry. Therefore, when we're working our way through a JOA dispute, we usually rely on ordinary first principles of contract law rather than detailed judicial guidance as to the meaning of specific provisions in JOAs. So most fundamentally, what does this mean? Well, it means that we're looking at the terms of the specific provisions in the dispute together with any other terms of the JOA which may be of assistance. So in very basic terms, given that these are generally fairly complex and heavily negotiated agreements, fundamentally, you shouldn't really be looking beyond the kind of four walls of the contract, and you're really just looking to assess, well, what does the contract actually say? What do these words actually mean? So just moving on to the next slide. General principles, again, Fiona will get into more of the detail here. It's up to me to kind of set the scene, and again, I think most of you in the room will know, what is contractual interpretation? Well, it is looking at the words, it's trying to work out what the words mean, and the reason that we're doing that is because we are trying to determine what's the genuine intent of the parties when they contracted. So it's objective. It's not the subjective intentions of the parties. And one way of looking at it is, well, what would a reasonable person, with all the background knowledge available to the parties at the time, have understood the language to mean? And I think that can often be a sticking point, and we may speak about this a bit later on, particularly given the age of some of these contracts and when they were entered into. When the courts are looking at what a reasonable person with the background knowledge available to them would have understood the language to mean, and this comes out quite clearly in some of the cases we'll look at, it's at the time that the contract was entered into. So market practice, parties' understandings will have moved on significantly over the life of the contract. But the key is that as far as the courts are concerned, it's about what did they understand when they were actually agreeing this word in the contract or this particular clause in the contract, not what they now understand to be the case, potentially 10, 15 years further down the line. And then the final point there, the court's generally reluctant to conclude, as I said before, that parties to a complex commercial agreement, such as a JOA, where both sides will have been legally represented in the negotiation, will not have expressed their intentions accurately or fully, and that's reflected fairly regularly in case law to the extent that we have it. So a case that all the lawyers in the room certainly will be familiar with and still referred to as the kind of key point and key case on contractual interpretation, Arnold against Britain. And again, just really underlining the points that I was making there by way of introduction. What are the core fundamentals when we're interpreting contracts? Well, first, loyalty to the text. What are the words in the provision? Do they have a clear meaning as a matter of language? Because that should be the starting point. Importantly, the whole contract approach, and this is often a way that a clever barrister will look to try and maybe undermine what might initially appear to be clear provisions in a contract by showing that there are, say, inconsistencies. Are there other relevant provisions or a provision that might not make sense when it's read alongside the particular interpretation of another clause? So I think it's important, if you're arguing about a particular clause, you do have to work your way through the whole contract and particularly see, are there any kind of inconsistencies with that interpretation? Are there any clauses in the contract that would effectively be obsolete if your interpretation found favour with the court? Those are the sorts of arguments that generally tend to be brought in when you're looking at this whole contract approach. What's the purpose of the provision and what's the purpose of the contract as a whole? What's the purpose? Particularly often these disputes relate to, obligations of operators, how the operator is supposed to behave. What is the thrust of what is said about what the operator's duties, responsibilities, whether or not liabilities should sit with an operator? What's the general thrust of what's being said in the contract and the GOA about that sort of thing? Context, relevant, factual, legal, regulatory background can be key, particularly in relation to things like reasonable and prudent operator. And then commercial common sense, although I have to say, commercial common sense, both sides will argue equally as strongly that their interpretation is the commercially sensible one. I'm never convinced that a huge amount of value is attached to the commercial common sense, unless one side is genuinely arguing for something that would lead to a completely absurd or excessively punitive outcome that neither party or no party could sensibly have contemplated when they were entering into the agreement. But as we will all see, you generally find that both sides will be adamant that commercial common sense favours their interpretation. So moving on to a case. Now, Fiona's going to speak about this case in a bit more detail, and apologies. I think we have representatives of both TACA and Rockrose attending. It's inevitable. But all I will say in our defence is we don't have very many of these cases, and we have to pick the ones that we have. And also, I would say this. Even though you may be in the room while we're talking about a case that you were involved in, it's certainly not going to be any worse than it was for my flatmate at university who ended up speaking about his own parents' divorce during a family law seminar. So, there's always that. There's always somebody worse off than you. But we won't, there's elements of the fact in these cases that we're going to want to talk about. But really what we're looking at here in reviewing these cases is what the court were telling us about how they were interpreting the contract. So briefly, in the TACA case, what happened was that the operator was removed under an express provision of the GOA, and I've put the clause on the slide there, clause 19.1, and what you can see there is that at the end of a period, it was a straight notice provision, and that if that notice was served, then the operator was to be removed after a period of time. Now, that removal was challenged on the basis, firstly, that it was argued by Rockrose that the clause was qualified by an implied duty of good faith, and or that the GOA was a relational contract, and so removal was in breach of implied obligations of mutual trust and confidence. And I think we'll talk about this in detail further on, but you can already see, based on what I was saying at the outset about the court's approach to these kind of contracts, that what Rockrose were arguing for was implication of terms, and in particular implication of a duty of good faith, and separately that there was an implied obligation of mutual trust and confidence. So not to just look at the words, but that there was a requirement to read more into the words or to imply terms. So because reading the words on the face of it was not helpful to the position that Rockrose was advancing, that this couldn't be done by a simple notice procedure. And just moving on to the next slide. So what happened in that case? Well, the commercial court heard that the removal had been exercised lawfully. The relevant provision was clear and unambiguous, and the court reached this decision based on the ordinary principles of contract interpretation that I mentioned earlier on. Just pulling out exactly where this is mentioned in the TACA case, in clear words, paragraph 35, the language used in my judgment, and this is in the GOA, is clear and unambiguous, and where the parties have used unambiguous language, the court must apply it. Contractual context, the language used elsewhere in the contract emphasises that the parties intended the provision to have the effect I conclude that it has. So that's the point I was making about reading the contract as a whole. There were no inconsistencies with this clause operating the way that it was drafted. And then overall purpose of the contract, as is apparent from the clauses in the GOA, the relationship was not and was not intended to be a partnership, and the parties were fully entitled to vote at operating committee meetings in accordance with what they perceived to be their own best interests. So there was no restriction or limitation on the way in which parties were required to vote, and that would be unusual if there were. And then finally, just in terms of good faith, Fiona will speak about this in more detail in relation to what was said in the TACA case, but just by way of scene setting, there is no general doctrine of good faith in English contract law, but what we are seeing more and more of is parties including duties of good faith in contracts. And this is much more, this is often an element that confuses lawyers coming from European jurisdictions, where I think there is an expectation, or it's generally kind of implied, that they will behave with good faith towards one another. But I think the starting point, certainly in English law, is that there's no expressed, no implied duty of good faith. You just have to do what the contract says you have to do. Obviously, that changes if you actually have an express duty of good faith in a contract. If you include a duty of good faith, then, as I said on the side, the scope will depend on the wording itself. But in general, what does it mean? Well, it will mean there's a duty to act honestly, a duty to be faithful to agreed common purposes derived from the agreement, not to use powers for an ulterior purpose, to deal fairly and openly, some degree of transparency, and to consider and take into account their own interests, importantly, whilst also having regard for the other party's interests. So it has to be much more of a balanced approach. So where would we commonly see a duty of good faith in a GOA? Well, that quite often features in the reasonable and prudent operator test, which Fiona will speak about in a bit more detail later on. But that's all from me. I'm going to hand over to Fiona now to just walk through the TACA case in a bit more detail, and particularly to pick up on this point about good faith.
Thanks very much, Iain. Good morning, everyone. Thanks for joining us today. So as Iain said, we're going to look at the TACA case in a bit more detail. And in this case, the operator sought to argue that the JOAs included an implied obligation of good faith, but it's not really a spoiler. The judge rejected this argument. So again, the general principles relating to implying terms into contracts will apply to joint operating agreements in the same way as for any other type of commercial contract. So we put the key principles here on the slide. It's only after the process of construing the express words is complete that the issue of an implied term falls to be considered. Terms are to be implied only if to do so is necessary in order to give the contract business efficacy, and an implied term must not contradict any express term of the contract. So we've added here a short extract from the judgment, and the judge held in the TACA case, it is not necessary to imply any of the terms for which Rockrose contends, either in order to give business efficacy to the JOAs or in order to give effect as to what was so obvious that it went without saying. So just to look at this in a bit more detail, one of the operator's arguments in relation to good faith was based on an assertion that each of these joint operating agreements was a relational contract. And the operator argued that on that basis, an obligation of good faith fell to be implied into that termination provision that we had on screen earlier on. So first of all, what is a relational contract? Well, the term comes from the case of Yamseng Private Limited and International Trade Corp Limited. And in that case, the judge said, such relational contracts may require a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence, and involve expectations of loyalty which are not legislated for in the express terms of the contract, but are implicit in the parties' understanding and necessary to give business efficacy to the arrangements. Examples of such relational contracts might include some joint venture agreements, franchise agreements, and long-term distributorship agreements. So we can see from that definition that it's only a restricted subset of commercial contracts that will be relational contracts. There needs to be an element of mutual trust and confidence and expectations of loyalty involved. Now, clearly, that will not be the case in a standard arm's length commercial arrangement, but you can understand why certain joint venture agreements might well meet this definition. And it's at least possible, therefore, that joint operating agreements that are proceeding as joint ventures might meet the test for a relational contract, but depending, of course, on the wording of the joint operating agreement itself. So just moving to the next slide there. It's important to remember, though, that it's not the case that wherever there is one of these relational contracts, then there will automatically be an implied duty owed by each party to the other to act in good faith. It's just that the courts may be more willing to conclude that there is such an obligation than in a non-relational contract. So in TACA, the judge held it is not necessary, indeed it would be wrong to imply such a term to qualify the power on which the claimants rely, because it is not necessary in order to make the contract the parties have chosen work as it is to be presumed they intended it to work, or to the extent there is any difference, to give effect to their presumed common intention. So here in this case, even if the court had held that these joint operating agreements were relational contracts, that would not in and of itself have automatically meant there was an implied duty to act in good faith. Although I should say that the judge here basically treated these joint operating agreements as being at least arguably relational contracts so that this idea could be tested. But the court emphasized that the basic test for implication of terms still applies. So whether it's a relational contract or a non-relational contract, you've still got this same test for implying duties, which is that it has to be necessary for business efficacy. So the court concluded in the TACA case that the right in question was absolute and unqualified. And because the parties had legislated on the terms of the relationship, it was not necessary to imply such a term into the provision. So on the point of reasonable and prudent operator, which Iain mentioned earlier, we wanted to have a look at this concept because, as you'll know, it'll almost always invoke the concept of good faith. But what does it actually require acting as a reasonable and prudent operator? Well, it usually requires some combination of the performance of contractual obligations in good faith and then to a certain prescribed standard. So a common standard is the level of skill, diligence, and prudence that would be expected from a skilled and experienced operator engaged in the same type of undertaking under similar circumstances and conditions. So if we just look at a typical reasonable and prudent operator definition clause as an example, this one comes from the case of Scottish Power UK PLC and BP Exploration Operating Company Limited. And we'll have a look at this in a bit more detail in a few slides' time. And here you can see that the key elements of the definition have just been underlined. So there's the concept of good faith. It's about the performance of contractual obligations, and it's about performing that to a certain standard with a certain degree of skill, diligence, prudence, and foresight that's up to a comparative level with other operators in the same type of undertaking and in similar circumstances. So it's important to note, despite its prevalence, it's been used for a very long time, it's not a standalone legal concept with a commonly accepted meaning, but its meaning will derive from the express terms of the particular joint operating agreement. And that's understandable because it's not one standard definition that's used in every joint operating agreement. There will be variations, there will be revisions to it. And again, we're back to the basic question, what does the contract say? It's all going to be down to the standard principles of contractual interpretation that Iain went through earlier on, coming from the Arnold and Britton case. And so precisely how the definition is drafted and any non-standard revisions might have a significant impact on the scope of the reasonable and prudent operator obligation and how it applies in any dispute, even to the point where existing judicial authority on one particular reasonable and prudent operator clause might not end up being of very much assistance in a future dispute because the wording can vary. So what will the court do if it's tasked with assessing whether or not an operator has met the standard of a reasonable and prudent operator? Well, as I just said, it's going to perform the same task of contractual interpretation that we've been discussing. The starting point will always be the express words used. So what is the natural and ordinary meaning of the language? And in some contractual clauses and in some disputes, that can be the entire end of the matter, really, because as the judge said in Tucker, where the parties have used unambiguous language, the court must apply it. When we've got reasonable and prudent operator definitions, though, there'll almost always be at least some words that have nebulous meanings or invite in some element of subjectivity. And so the court will then need to apply the other rules of contractual interpretation. So they'll need to consider the reasonable and prudent operator provision in the context of the contract as a whole, look at any other relevant provisions of the JOA. The court will need to take into account the purpose of the contract and the relevant factual, legal, and commercial matrix. And finally, if the wording is ambiguous, then the court will prefer the interpretation that most accords with commercial common sense. So as I mentioned when we showed that example of an RPO definition, a good example came before the Commercial Court in 2015 in the Scottish Power case. And in this case, BP and others had agreed under long-term agreements to sell to Scottish Power natural gas from the Andrew field. Between 2011 and 2014, production was halted in order that work could be done to tie in a nearby field to the Andrew platform. And this work was to the commercial benefit of the sellers, but to the detriment of Scottish Power. Now, even though the sellers weren't operators, the relevant agreements required the sellers to act as reasonable and prudent operators, and the agreements included a reasonable and prudent operator definition, as you'll see there on screen. So it's the same one we looked at before: good faith, performing contractual obligations, and then having to perform them to that prescribed standard. Scottish Power commenced proceedings against BP and the other sellers, alleging, amongst other things, that by failing to provide natural gas under the agreements, they were not acting as reasonable and prudent operators. And just staying on this slide for a moment, if we just break this down further, we can see that this definition, it's in effect a two-part definition. There's the seeking in good faith to perform contractual obligations part, and then there's the standard to be met whilst doing that. So to be a reasonable and prudent operator, you need to satisfy both parts of that test. You need to be seeking in good faith to perform your contractual obligations and meeting the prescribed standard. If you only meet one part of the test, then you're not a reasonable and prudent operator, and that was important in this case. So moving to the next slide, in this Scottish Power case, the two sides emphasize different elements of the first part of the test. Scottish Power focused on the requirement that the sellers had to be seeking to perform their contractual obligations. And they argued that if the sellers were not doing that, then that part of the definition was not satisfied, and the sellers therefore could not be acting as reasonable and prudent operators. And then the sellers, on the other hand, emphasized the good faith aspect. They sought to argue that as long as they were acting in good faith, it was essentially okay for them to not perform their contractual obligations, and even to deliberately not perform their contractual obligations, as long as they were satisfying the other aspects of the test, so acting in good faith and reaching the required standard. So the decision taken was one which an operator acting reasonably and prudently could have taken. So the commercial court was asked to decide on this, and it interpreted the definition, again, using the ordinary principles of contractual interpretation that we've been discussing. And the court preferred Scottish Power's interpretation, finding that to be most consistent with both the words of the clause and the commercial context. And the judge even concluded that the sellers were essentially trying to read this definition in an unnatural way by focusing excessively on the good faith part and ignoring the fact that it was all about the performance of contractual obligations. So I'm just going to read out a short section from the first instance judgment, which was upheld on appeal. It's not on the slide, but it's paragraph 79 if you want to look it up. And the judge said, "What is clear is that a person seeking to perform its contractual obligations in good faith must, on any view, be a person seeking to perform its contractual obligations. The approach taken by the Andrew owners effectively tries to read that requirement out of the contract and deprives the words seeking to perform its contractual obligations of any relevant meaning." So again, this case is just a good example of contractual interpretation focusing first on the words used, but also considering the wider commercial context, and also considering that where you have two competing interpretations, if there's one that is more natural, that one will be preferred by the court. So we're now going to have a brief look at the issue of contractual discretion. That's a concept that can often arise in joint operating agreements, and it was an issue in the Tucker and Rockrose case that we discussed earlier. So as you'll know, joint operating agreements will often confer on an operator a degree of discretion as to whether, when, and how it takes a particular step. Now, that discretion might be expressed or implied in circumstances where the agreement is vague as to when and how a particular step ought to be taken. And then operators will often rely on such discretions in order to justify the particular approach that they wish to take. Now, we discussed implied terms earlier on, and how the general test is that terms are to be implied only when necessary in order to give the contract business efficacy. Well, when a contract confers a discretion, either expressly or impliedly on a party, the situation can be a little different. In such a situation, English law will imply into the contract a duty of rationality and good faith known as the Braganza duty. So what is the Braganza duty? It's an implied obligation in the absence of clear language to the contrary to exercise a contractual discretion in good faith and not arbitrarily or capriciously. The Braganza duty includes a requirement that the decision maker must properly direct itself to the task in hand, and importantly, not exercise the discretion in furtherance of an ulterior motive. and there should be some logical connection between the evidence and the apparent reasons for the decision. So essentially, a Braganza duty is an implied duty to take decisions rationally and in good faith. So when an operator has a discretion, and it has to be a true discretion, which is important in the TACA cases we'll discuss in a moment. If it has a discretion, it cannot, in exercising that discretion, take into account considerations which are not relevant to the joint operating agreement and the interests of the parties thereunder. And this was raised in the TACA case where the operator sought to argue that the Braganza duty should be implied into the termination clause. So let's just remind ourselves of that termination clause, which we'll find on the next slide. So the operator may be discharged by giving not less than 90 days notice. And then there's the voting requirements. So the votes of the operator and any affiliate of the operator are disregarded. And if 100% of the remaining parties all agree, then the operator may be discharged. So the judge concluded in this case that this clause was not qualified by an implied Braganza duty to exercise the discretion to terminate in good faith. And the reason for that is set out here, comes from paragraph 46 of the judgment. The judge said, I consider it clear that on the current state of the authorities, the Braganza doctrine has no application to unqualified termination provisions within expertly drawn complex commercial agreements between sophisticated commercial parties, such as those in this case. So essentially, even though termination provisions can be thought of in a sense as conferring a discretion, they won't be subject to an implied Braganza duty of good faith if they're otherwise unqualified provisions. And this can really be thought of as an exception to the Braganza doctrine that will apply to other types of contractual discretion. So just to recap, oh, sorry, if you don't mind popping back to the previous slide just for a second, thank you. Just to recap the kind of the good faith arguments that were made in this case. The operator tried to bring in an implied duty of good faith by two main routes. Firstly, by arguing that this was a relational contract in line with the Yam Seng case. And then secondly, by arguing that the discretion was qualified by the Braganza duty, as we've just seen, but the judge disagreed on both counts. So before we finish up, I wanted to touch briefly on a final point, which was addressed tangentially in the TACA and Rockrose case, and which also relates to the concept of good faith that we've been discussing today. And that is an operator under a joint operating agreement a fiduciary? So what's a fiduciary duty? Well, it's easiest to think of it as a trustee-like duty. It's an equitable entitlement that arises between contracting parties in certain circumstances. And who is a fiduciary? Well, there's a useful definition here in the Bristol and West Building Society and Motteview case. And here, a fiduciary was described as someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. A fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interest may conflict. He may not act for his own benefit or for the benefit of a third person without the informed consent of his principal. So you'll see that it places far more onerous duties on a part than you would expect in a normal commercial relationship. So examples of persons who owe a fiduciary duty are agents to their principal, trustees to the beneficiaries of the trust, and company directors to the company. And why is this something worth considering in the context of joint operating agreements? Well, if you can establish that there's a fiduciary duty on the part of an operator, that allows other participants to access other remedies besides those that are ordinarily available for breach of contract. The usual remedy for breach of a fiduciary duty is damages based on an account of profits, in which the fiduciary is essentially required to pay over the gain it has achieved as a result of its breach. And there's therefore no need for the claiming party to have suffered a loss or to quantify that loss. So it's generally an easier remedy to secure. JOAs do not generally expressly provide for a fiduciary relationship, and it would need to be implied into the contract. And so we're back again to the rules regarding implied terms that we've been looking at today. A fiduciary relationship will only be implied if it's necessary for business efficacy, and it will not be implied if it would contradict an express provision in the contract. So what will the court consider if it's asked to answer this question? The court will consider whether the operator is acting as the agent of the joint operating agreement parties to any extent. And this will depend on the terms of the joint operating agreement as to the powers of the operator. And if the operator is an agent, then it will owe fiduciary duties. The court will also look at how much freedom of action the operator has. And the greater the power and freedom the operator enjoys, the greater the possibility that it is a fiduciary. And finally, the court might look at whether the operator holds property on trust for the other participants under the joint operating agreement, which would make it a trustee and therefore subject to fiduciary duties. The general position, though, is that the court is going to be reluctant to imply fiduciary duties into a complex agreement, such as a JOA, because the whole purpose of it is to set out the parties' relationship and their rights and responsibilities towards one another. The courts, they won't seek to disturb a contract in which the parties have made their respective roles very clear, and parties are free to do that. And this was borne out in the Tucker case. The judge made some obiter comments on the point in paragraph 19, as you'll see here on the slide. So he said, it was suggested on behalf of the claimants that the role of operator was akin to that of an agent. I doubt whether that is a correct approach. The reason why the role of operator is explained at length in the JOAs is precisely to avoid the need for recourse to agency concepts in the general law. And so the final point just to make is, as we've said, under English law, a term will not be implied that would contradict an express provision. And it's for that reason that some model JOAs will expressly exclude fiduciary duties. And that's to ensure that the operator cannot be deemed to be a fiduciary, and to ensure that the other participants can't access that easier remedy of an account of profits. There'll be other provisions also that will often limit the scope for a claim for breach of fiduciary duty, such as an entire agreement clause or a limitation of liability clause. So that's all that we were going to cover today, but as Iain mentioned earlier on, we've included some of the key cases on joint operating agreements, just in case you want a bit of light reading. And we're also happy to take any questions that you may have, if there's any in the Q&A function.
I will have a quick look. So we've got a couple, Fiona. The first one, I think, it relates to something that you spoke about. So if I can pose it to you, and it's back to this Braganza duty that you were speaking about. And really, I think, well, the question is, I think maybe can you expand a bit on why there was no Braganza duty in the Tucker case, given that it seemed like it was a discretionary approach. There was a discretion afforded as to whether or not to terminate. Why, therefore, were we not in Braganza territory in the Tucker Rockrose case?
Sure. So essentially, it's because there's already case law specifically on unqualified termination provisions. And so the judge in the Tucker case was basically bound to apply that. So essentially, the case law says that a Braganza duty does not apply to an absolute contractual right, and that a party should have an unfettered right to exercise that. So the case, if anyone wants to look it up, is Compass Group UK and Ireland Limited and Mid-Essex Hospital Services NHS Trust. So the idea is, if you've got an absolute contractual right that does not require any justification or any kind of reason for the decision, as was the case in Tucker, it didn't say in the provision that the parties had to have any reason for the removal. It was just a straightforward reach the required threshold of votes, and then you've got the removal. If you're in that sort of territory, it's not really a contractual discretion in the Braganza sense. A Braganza duty is more likely to be implied where there's very obviously a discretionary decision-making process. So, for example, it's been held to be implied where an employer is deciding whether or not to award a bonus to an employee. And in those cases, the Braganza duty will be implied, and the decision maker has to make the decision rationally and in good faith. So really, in the TACA case, we should just think of that termination provision as not really a discretionary provision in the Braganza sense, and that's why it doesn't apply.
Okay, thank you. And just one other question, I think maybe me rather than you, but well, so I was speaking about the assessment of what parties' understanding was when it came to kind of interpreting commercial terms, particularly in terms of whether there was a need to imply terms, and the fact that the timing of that assessment is at the time that the contract was entered into. And I think quite rightly somebody's raised, well, what if the contract has been amended? How would that impact on that? And I think, well, it would depend on the scope of the amendment. But I mean, strictly speaking, if there is an amendment to a term, then the parties, if the question really only relates to the term that's been introduced by way of amendment, then the time that that amendment was entered into would be the time, the understanding of the parties at the time that the amendment was entered into would be the relevant time for those purposes. I think the issue that you're going to have with that is, generally speaking, if there is an amendment, often it's not a comprehensive amendment that fundamentally changes the contract. It may change an element, and I think you may still end up running into difficulty in terms of how that particular amended term then interacts with other terms that have remained in place. But I think, in terms of wider points here, it is another reason that there should be a contract review process, that if there are updated market practices, if there are changes to approaches, it's another reason for continuing to look at particularly older agreements like JOAs, and making sure that actually, rather than having to look at implied terms or implied obligations, that those terms actually reflect the practice on the ground, so that we don't end up in the territory that we often find ourselves in, where there is a practice, but that practice is not actually reflected in the contractual documents, and that is just a bit of a mess for all concerned. We will probably just bring things to a close. So I'll just thank Fiona, and thanks to everybody for joining us today. I hope you did find this useful. Please keep an eye out on the website, brodies.com, for details of our next Energy Academy sessions and other events. We also, if I could ask, we have a feedback survey which will pop up on your screen when you leave the webinar. It takes less than a minute to fill in, with only 6 questions, and the feedback is appreciated, as it will help us shape the future of our events and our webinar programme. But other than that, it's just for me to say thank you for joining, and goodbye for now, and hopefully speak to you all again soon.
Thanks, everyone.
Thank you.